Hi, everyone. I'm Monica Hakimi from the University of Michigan Law School, and I'd like to welcome you to our panel on cyber power and its limits. The topic almost doesn't need an introduction. We all know just from reading the news that our collective dependence on cyberspace is also a huge vulnerability. And state and non state actors exploit this vulnerability to do one another harm. They use cyber technologies not just to spy on one another, but also, for example, to interfere in national elections, to steal trade secrets or other valuable information, to disrupt the activities of political, military, or economic institutions, and at times to cause physical destruction or death. Moreover, because these technologies allow the perpetrators to obscure their identities or the full effects of their operations, the people and institutions that are affected don't always have the relevant information to protect themselves from future attacks or to respond. In 2013, a group of governmental experts convened pursuant to UN General Assembly Resolution 68243 stated that, quote, international law, in particular the Charter of the United Nations, is applicable and is essential to maintaining peace and stability and promoting an open, secure, peaceful, and accessible ICT, meaning information and telecommunications, environment. Later instruments have confirmed and elaborated slightly on the premise that the general principles of international law apply in the cyber domain, but there continues to be questions about how international law applies and how it might be supplemented by other non binding norms to regulate cyber conduct. And it's these questions that we want to explore today. I'm delighted to introduce our panelists, which I'll do relatively briefly in order to save time for discussion. And I guess I'll just ask, given our format, that you raise your hand as I introduce you so our viewers can know who I'm talking about. So first we have Charles Allen, who has served as Deputy General Counsel for International Affairs at the US Department of Defense since 2000. Second, Xizhang Huang, who is a professor at Wuhan University School of Law and has served as one of the experts who worked on the Talon Manual 2.0 cyberspace law project. Third, Sue Robertson, who serves as First Assistant Secretary of the International Division in the Office of the Attorney General of Australia and has previously served in the Australian Department of Foreign Affairs and Trade. Next, Anne Valahatanga, who has served as an international law researcher at NATO Cooperative Cyber Defense Center of Excellence since 2016. And last but certainly not least, Doug Wilson, who was formerly the legal director at the Foreign Commonwealth Office and is now at the UK Government Communications Headquarters, or GCHQ. We've decided to organize this panel more as a conversation than as a series of presentations. So I'll pose some questions to the panelists to facilitate the conversation among them, and I'll incorporate as much as possible some of the questions that ASIL received through the online format in anticipation of this panel. And to start, I guess I just want to focus on the question of what activities, when conducted by states in the cyber domain, are internationally wrongful. So, Anne, perhaps I could start with you and ask whether when one state uses another state's territory to engage in some kind of cyber conduct, for example, to use its servers, without that territorial state's consent, does that per se violate some principle of international law in your view, such as state sovereignty or territorial integrity?
According to my reading of the Tallinn manual, it still seems that what is the main determinant factor is the manifestation of the use of the cyber infrastructure. And if the manifestation itself brings about something that could be quite described as violation of sovereignty, then yes. But at the same time, this is not a crystallized principle or rule. And when we compare this kind of position to what the law says or what the practice even says in other domains, then we see that it's a bit in conflict. Because, for instance, the mayor trespass into the area territory of another state is a breach of sovereignty, and so therefore it's still up there, but most likely it will depend on the manifestation. If the uses are peaceful as such, then probably it wouldn't be described as a breach of sovereignty. But then again, we come to maybe the major apple of this content of cyber law in these days is whether sovereignty as such can be breached, or is it merely a principle, a guiding principle, and not a rule that you have to obey, or either you are violating it.
So if I'm understanding correctly, what you're saying is that there's a question about whether um, the mere use of another state's territory without its consent violates sovereignty, some sovereignty principle, or needs to violate some other principle of international law.
The thing is that what does consent mean? If, for example, one state is using the servers that are located on the territory of another state, yet still operated by a private actor, and there is using very peaceful purposes, or even, as some experts have claimed, even for perhaps purposes of mere interception or espionage, then whether or not it's a breach of sovereignty is still kind of disputable.
Mm-hmm. Shishang, I saw you gesture. Did you want to jump in then?
Mm-hmm. Hi, yes. I think this question very much depends on how sovereignty and territorial integrity is to be defined and interpreted in the cyber context. And we can see states and scholars do have quite different views. For example, if we look at the position paper released by France in last September, which states that, quote, any cyber attack against French digital system or any effect produced on French territory by digital means, end of quote, attributable to another state would constitute while a breach of French sovereignty. Then very likely for France, the answer would be yes. But as was mentioned just now, there are also states holding that sovereignty is not a rule of international law entailing concrete obligations. So for them, the answer, I think, would clearly be no. China, as far as I know, has not yet made its position very clear. But my understanding is that very likely China will be more or less in agreement with the French petition.
Mm-hmm. Chuck, please go ahead.
Yes, thank you very much. I noted that that Anne mentioned the dichotomy between sovereignty as a rule and as, on the other hand, as principle, and that was also discussed by our Chinese colleague. And what I wanted to say was that in the United States, we've really tried to grapple with these almost intractable issues, as Monica mentioned at the outset. And in a series of speeches going back to legal advisor Harold Koh in 2012, legal advisor Brian Egan in 2016, and then most recently in more of a shortened version by the General Counsel of the Department of Defense, Paul Nye, we have addressed this. And I also note that the UK Attorney General in 2018, in a very persuasive speech, addressed this as well. And our view is that there, at least at this point, and we understand things are evolving, is that there is not sufficiently widespread and consistent state practice resulting from a sense of legal obligation to conclude that customary international law generally prohibits such non-consensual operations in another state's territory. That is, with the important caveat that that effort, that intrusion, if you will, does not constitute a prohibited intervention or use of force. So it does not interfere in violation of Article 2.4 in a country's right against incursions on its territorial integrity or political independence. And I think that the UK speech is particularly persuasive on this point. You know, in saying that sovereignty is, of course, fundamental, and the United States agrees with that, to the international rules-based system, but that we just don't see that there is a rule as a matter of current international law that prohibits us from, as the United States has said recently, being able to defend forward, perhaps including incursions in other countries, to protect such vital elements as elections, election results, the integrity of the election process.
Okay, wonderful. Thank you. So maybe, Sue, I could turn to you and ask just first if you want to state what Australia's position is on this particular question. And then second, if we could then move to a more specific question, which is when cyber conduct violates the principle of non-interference in another state's affairs. So, okay, if we accept, as some do, that cyber conduct does not necessarily violate some general principle of sovereignty, can we get more specific and talk about the principle of non-interference? And particularly, maybe we could focus on the question of interference in a national election. What kinds of interference might actually violate this principle of non-interference? And must it include some element of coercion? And if it must, what qualifies as coercion in this context?
Yeah, thanks, Monica. I think in relation to just quickly touching off on this issue of the rule or the principle of sovereignty, I think like the UK and the US, Australia's position is we're not quite there yet. That this is a contested view. You know, some states, France, the Netherlands, have said they're in favour of it. We don't have a public position as of yet. We think the question is a challenging one, but that state practice is basically still evolving in this area. And I guess I might just also pick up on something our Chinese colleague, Professor Hung, just mentioned as well, that the issue of interpretation of the different principles is key here. So, for example, it may be that depending on a state's interpretation of prohibited intervention, for example, that there may not be a lot of difference in practice between a violation of sovereignty and a violation of prohibited intervention, but it depends on where those lines are actually drawn. But of course, Australia does believe in a principle of state sovereignty in cyberspace, and obviously a state has sovereignty over its cyber infrastructure, for example, located on its territory, and the cyber activities that it does on its own territory. Moving to, I think you've raised the question more specifically of electoral intervention, which I think is a really apt one because it's a classic grey zone area, I think, where there may be a whole lot of activity that goes underneath an internationally wrongful act of prohibited intervention. And I should say that for states, I think cyber interconnectedness has raised the stakes on a whole lot of critical infrastructure and governance processes, not just elections. And a huge focus of legal advising is on how to protect that critical infrastructure that can obviously affect millions of people and their well-being in terms of hospitals or electricity or finance and those sort of realms. But I think it's important to say that states do have a variety of tools, and international law is one of them. But turning to this issue of prohibited intervention, as we know, it has two components. The two constituent parts. First, a state must interfere by coercive means, and that requires them to intervene in the domain reserve, something that is essentially within the right of that state to control and choose. And you know, we've talked about this in various ways. And I would say that out of domain reserve and coercion, as an advisor, coercion is generally the more difficult to advise on. And I think that's because it's still an indeterminate concept in some ways. It can't be merely persuasion or pressure. That's just a matter of statecraft. But, you know, we know from Nicaragua that it goes to this issue of states' choices, which must remain free ones. So just quickly on the example of elections, I think Australia would agree with the UK Attorney General and others who have said this, and our own Attorney General has also made some statements on it, that cyber operations which manipulate an electoral system would satisfy that test. And I think others, including the Netherlands and the UK, have agreed on that. But I think it's an open question, the extent to which other types of interference in elections actually reach this threshold or not. And perhaps there we could talk about interference in the US democratic elections, for example, in 2016, in which the US government did not respond by characterising those necessarily as an international wrong. They took a whole lot of other steps using tools such as sanctions and criminal prosecutions and so on. So I think that does raise the issue, that does show the example of how difficult this issue can be.
Doug, please go ahead.
Thank you, Monica, and thanks to you and ASIL for having me. It's a real pleasure to be alongside such distinguished fellow panelists, many of whom it's a pleasure to see again. I just wanted to take us back, if I may, to the sort of conceptual elements of what we're discussing. We're discussing the promise and limits of cyber power under international law, and I think it's important, just briefly, to dwell on what cyber power means. And for the UK, we've been positing a public vision of what that concept entails. And there are three parts to it. There's the ability or the capability to protect the digital homeland, the cybersecurity element. There's the capability to project power and influence through cyber means to disrupt what adversaries are doing, for example, when the nation is threatened. But underpinning that, there's the legitimacy of law at the domestic and international level. And I think when we're discussing this, we ought to just bear in mind that those component parts, because what you do in one area and how you describe what's being done to you can affect your own ability to act. And it's, as international lawyers, we need to keep that balance in mind. For me, looking the way you introduced the first question, I thought was absolutely spot on. The real question we ought to be asking ourselves is a particular act or a series of acts or line of activity internationally wrongful? As international lawyers in this space, we're often quite concerned with the means of transportation rather than the destination. So we can have arguments about sovereignty and how it materializes into a specific rule, according to some, or into what everyone agrees is the rule around the prohibition on interference in internal affairs. So for the UK, and the question is really whether that the threshold of the prohibition on non-intervention has been met in a particular case. And what we've tried to do is, alongside other countries, US and Australia, France, Netherlands, Estonia, and probably others in the mix too, is try to populate the space with specific examples of activity that we think is internationally unlawful, and that we recognise states can arrive at that destination, as I say, by different means. The election one, as Sue's already said, is a really hard one, because for us, we were in the speech, the Attorney General's speech that Chuck was kind enough to mention. Thank you, Chuck. Flattery will get you everywhere. We deliberately couched that as manipulation of an electoral system with the aim of altering the result. And so, what that does capture, obviously, is with voting registers, electronic voting, postal voting, all that kind of things. But where there's more scope for progressive development or further discussion is around really tricky issues like disinformation and the whole host of issues that Sue touched on in her intervention. So for us, what we're really keen to do is see that space, the space of what's internationally wrongful, populated by real discussion of those type of examples. I know we're going to come on to some others, but what is unlawful in this space? What are the rules of activity in this new craft that we're all seeing develop and be used, and not only and be used for, as you said in your introduction, rather subversive means where countries are trying to disrupt and mislead states or their populations in a really unhelpful way. How can we bring some order to that, and how can we set up the rules of deterrence and proper conduct?
So that's great. So I'd like to actually take you up on that suggestion and hone in on, let's say, a specific example. Let's say the situation is one of a massive disinformation campaign that causes a population to call into question the election results, but there's not significant evidence of sort of tampering with the machinery of the election and the actual counting of votes or whatnot. Would that, in your view, qualify, in anyone's view, qualify as a violation of some principle of international law? I guess that's my first question. And my second question, just to have two on the table so that I do as little talking as possible and you all do as much as possible, is to what extent must states affirmatively prevent wrongful conduct, however it's defined, when conducted not by their own state agents, but by some non-state actors, either in their territory or outside their territories? This is what sometimes is called a due diligence obligation. To what extent do states have a due diligence obligation, an obligation to exercise due diligence to prevent some non-state actor from engaging in a wrongful in some harmful cyber conduct? And how do we define then the specifics of any due diligence obligation to the extent that one exists? So Doug, since you raised the question, maybe I'll come back to you and then sort of do a round robin with the other participants.
Yeah, no, I mean, to answer your extremely hard question, I mean, I think it's possible that it could, if it reached that level of a prohibited intervention, and a lot would depend on the facts. I mean, but I would come back to what Sue said earlier. International law is one of an array of relevant frameworks here and tools that can be used to combat that kind of thing. So a lot depends on the persuasive effect you can have on social media companies or big tech, and the domestic regulatory framework, which around the world you can see more interest in firming up the rules of the game and who's responsible for what to actively target misinformation. And you know what we're seeing right now in a number of places across the world, big tech and social media companies take a lot more proactive approach to this, which in itself carries a whole host of tricky issues to answer. When it comes to responsibilities around what's termed due diligence, I mean, for the UK, there's no doubting that states have obligation not to allow, in a knowing way, their territory to be used for acts contrary to the rights of other states. We can go back to Corfu Channel for that. Where there's a little more caution, at least for us, around due diligence is the content of any such rule. I think as a good international lawyer working for a government, you want to be sure when you're accepting the emergence of a new rule or the adaptation of rules from one area of international law to another. What does it really mean, and what does the content of that rule say? Because what we wouldn't want to do is oblige states to apply such levels of due diligence so that only a few states with a really sort of cutting edge system of cybersecurity would be able to meet them. I don't think there's any value in that. So again, interested in other views, interested in what the content of any rule that's termed due diligence might actually say. But there's no doubting the underlying general international law obligation about use of territory. It's just how it applies and what the standards are in that space.
Do you want to follow up? Sue, would you like to jump in on those
Thanks.
questions? Yeah.
Thanks, Monica. Yeah, I think Mike Schmitz, looked at these issues really well in a sense and talked about both views. What, in one example, if an election result is not manipulated, is that sufficient? But then puts forward the other view that, misinformation can actually cause events to unfold in democratic processes that would otherwise not have occurred. And I think there's definitely some merit in that. But I think it also highlights the real sticky problem we face, that the effects of various forms of indirect and direct misinformation and malicious cyber activity may not be known until a particular time. And so as time unfolds, things may actually get worse. And I note there's been some interesting commentary on that recently about interference in elections, where the effects can actually become worse over time. So we're left judging at a particular point in time is the point I just wanted to make there. And I think that the fact that a state does not characterise an activity as meeting a threshold doesn't necessarily mean that it does, that they do not share that view that it does. So, it's a bit of that secret life of international law that Daniel Bethlehem talks about so well, that, for a whole variety of reasons, they may not have decided to characterise it in that way, whether it is to protect a source or that because they can achieve their political shaming through another mechanism. Due diligence is a really good one. It's one we're still thinking about. I think it's crucial, and I think it will become increasingly more and more important as attribution just remains so difficult. So our view is it is unclear the extent to which states are obliged to exercise due diligence. And I think that's because of that lack of crystallisation, if you like. That's why we've been really supportive of the development of norms and more soft principles through the GGE and other processes, because we believe it's definitely worth exploring and taking a realistic approach, as Doug has already mentioned. I think that's important to actually say what would be expected for due diligence and what level of knowledge, and interesting questions about constructive knowledge as well come into it. So a lot more questions than answers for us at this stage. But I think that even putting to one side legal characterizations, politically it's going to become harder and harder for states to ignore the harmful activities that come from their jurisdictions.
Chuck, did you want to weigh in on that question?
Yes, just briefly, because I think that Douglas and Sue really handled it about as well as one can. It's an intractable problem to know whether a disinformation campaign amounts to the kind of coercion that would be actionable. And I appreciate the statement of the ICJ Nicaragua case principles very clearly by Sue. Those apply. I think that it's been made clear, I think, particularly in General Counsel Nye's speech in March of this year, not necessarily in the smaller international law part, but in talking about the U.S. approach to trying to deal with the interference that has occurred, that, I guess the buzzword is defend forward, that we believe that it is appropriate to be able to defend forward, including consistent with the principle, as we say in that speech, of sovereignty, but nevertheless to be able to defend forward to counter foreign cyber activity that targets the United States, case in point being the integrity of the election process, and that this indeed comports with our obligations and our commitment to a rules-based international order. But again, I'm not sure I can add very much substantively to what Sue and Doug said. On the due diligence question, I found in a couple of years ago, group of governmental experts, U.S. statement, I think it might have been 2015, that we indicated that we did not see that there was an obligation of due diligence. And I think it's generally that true that states are not exercising due diligence. So from a perspective of custom and practice, it's kind of hard to say that there is that that obligation. On the other hand, it is just as true that it is, as has been said, states do not have the right to conduct or harbor in their territory cyber activities that are used to harm other states. And so, again, we would say that our efforts, including Defending Forward, are to counter such activities would not be a violation of the principle of non-intervention. Having said that and kind of backed away from an obligation of due diligence, I do think that sovereignty principle reflects that there are both responsibilities and authorities. So if an activity is conducted within a state's jurisdiction, the state has certain accompanying duties to ensure the activities are not used to harm other states in violation, for example, of Article 2.4 of the Charter.
Okay, great. So why don't we shift a little bit from the question of, because I think we're getting into sort of soft territory. So why don't we shift from the question of what conduct is prohibited or required of states and turn instead to the question of how states may lawfully respond in the event that they are affected by some cyber conduct. And so let's just start with the difficult question of when cyber conduct qualifies as an armed attack so as to trigger the right to use defensive force, whether collectively or individually. And if we could be as specific as possible, I'll put this scenario on the table. So let's imagine a situation in which a cyber attack does not cause physical destruction or death, but rather, for example, causes a military installation to stall out for an extended period of time, such that that installation is inoperable. Not, let's say, in the midst of an armed conflict, but in, let's say, ordinary times. Would that, in any circumstance, qualify as an armed attack so as to trigger the right to use defensive force? Or must, the question is, the cyber attack cause some significant physical destruction or death in order to trigger that right? Shishang, maybe I could start with you and get your views on it.
I think the issue of what constitutes an armed attack in the cyber context has not yet settled, and the law is still evolving. So overall, I think the determination will have to be made based on case-to-case assessment, taking into consideration such factors as scale and effect, and also other factors like the intention of the operation. But I don't think we can conclude definitely that if there is a physical damage or death, then it will constitute an armed attack. For example, if a police or a member of the army of state A intentionally kills a national of state B without further justification, no doubt, in my view, this would be an internationally wrongful act of state A, and the legal responsibility will incur. But for the purpose of our discussion, this may or may not be seen as an armed attack. This is what I understand the situation in the real world. But in the cyberspace, how can we definitely conclude that as long as a cyber attack caused death or physical damage, then it is an armed attack? This is my view. So a number of factors should be considered.
Okay, wonderful. So good. So there are two questions then, let's say, on the table. One is whether at what point an cyber act that actually causes some physical destruction or death amounts to an armed attack. And the second question is whether it's ever possible for a cyber act that does not cause physical destruction or death, but causes some other harm. And I'm using a harm directed at a military because that seems like the most obvious kind of other harm, might amount to an armed attack. So with those two questions on the table, I guess what I'll do is I'll ask our governmental experts to weigh in, and then Anne, I'd like to come back to you when we talk about countermeasures, which is my next question on the table. Assume short of force, what other measures might a state do in response to a cyber attack? So Chuck, please go ahead.
So I know that you're getting at maybe not the worst types of cases of a failure, for example, triggering a nuclear plant meltdown, where I don't think there'd be any doubt that it would be considered a use of force, opening cyber-wise a dam above a populated area, things like that. That I think, as the professor just indicated, you'd have to look at the facts as they come on a case-by-case basis. One can imagine something that might cause a physical effect, but that would not necessarily amount to a use of force. On the other hand, I can see something, to get to your second scenario, that maybe causes no physical effect, no deprivation of oxygen to a hospital such that people die, or something like that. But rather, let's say, and you pose the question, I think, just right, if you're talking about military systems, if a country that has a right to use its armed forces to defend itself, they need to be prepared to do so in various scenarios. And if through a cyber attack, let's say even the logistics systems of the military are imperiled, are immobilized, so that that country's ability to conduct and sustain military operations in its own defense, in its own national interests, I think that could be considered a use of force under jus ad bellum that would warrant a response, obviously, as according to the requirements of military necessity and proportionality. So again, it would have to be looked at. I would say that the possibility that a logistics system is slowed down by 3 days in its deliveries probably would not warrant such a response in self-defense. On the other hand, truly crippling it so that your airplanes can't fly, your ships can't sail, that might be a different story.
Doug?
Thank you, Monica. And if I may say so, I feel for your students, because you're always asking these really hard questions. Look, I agree with what Zhishong and Chuck said. I mean, I would add 2 extra points from my own perspective. One is coming back or underscoring the intent point. Did the attack aim to do something more, and good cybersecurity or luck or whatever actually prevent that harm? Because you ought not to be punished as a state or restricted because you were able to defend against an attack that was going to do something much worse. So that's part of the consideration that's been laid out already. And I suppose the second point I'd make is, does it matter? Because what are you looking to do back, or how are you looking to respond? Are you looking to use diplomatic means? Are you looking to use other means of exerting pressure, like sanctions? Are you looking to take cyber activity in response, in which case you use the framework that applies to you? For the UK, that would be to look at what's permissible under our domestic legal framework, which is very tightly constrained and has considerable independent scrutiny. And then what does international law permit in this circumstance? And if you're signed up to a rule of sovereignty that's very constraining, that will limit you, and you need to go through these gateway means in order to justify any response. Whereas if you're applying the kind of the approach that Chuck outlined earlier, and our General Counsel Paul Knight has talked about, our Attorney General's talked about. You've got more freedom of maneuver in the cyber world to respond to these types of things without having to pin down exactly what has happened to you. In the way that would help me avoid answering your really difficult question.
My students try to do the same thing. Sue, would you like to weigh in on this question, or would you like to move on to the question of countermeasures, which I think Doug sort of led up by saying, well, in many circumstances, states will choose not to respond with force. They'll choose to take other measures, and that then enters into that territory.
Yes, I think, one point I just wanted to make was as fascinating as IHL is and the use of force and these questions, that we all love writing about and reading about, I don't think armed attack and the use of force is necessarily the bread and butter of my advising day to day. I would say the grey area probably takes up 90% of my time, more, 99% more of my time. It doesn't make it not an important question, but I think it does go to this point of Doug's that how you characterise things, of course, it matters. But I think I don't think states are looking to characterise things as a use of force in any eager way, because the appropriate response may well be something quite different, and you really just want to end and cease the various cyber things that are going on there. And I think, the basic point is, look, as a matter of law, the Charter, Article 51 will apply. It will apply in cyber. It's not easy because of the indirect and direct consequences, because of what Doug said. It may or may not be successful. I certainly think it is difficult to think, of examples to reach the threshold of an armed attack where physical destruction or death had not occurred. I think that is quite difficult. But rather than focusing on immediate physical effect, I think a more useful framework that we use could be to focus on what is reasonably foreseeable consequences of a particular cyber operation and the level of interference in state function there. So that's sort of the armed attack point. Countermeasures, yes, an important consequence of finding an international wrong. They have their own limitations, of course, but they are an important consequence that states can explore.
Okay, wonderful. And just for viewers at home, when we speak of countermeasures, we generally refer to conduct that is otherwise unlawful, but is permitted in response to an unlawful act by the other side. And so you sort of suspend your ordinary obligations in response to, let's say, an unlawful cyber attack. And then there's, of course, a second category of unfriendly conduct that a state might take in response, known as retortions, which is not otherwise prohibited and is always available to a state. And the state may presumably use retortions in response to a cyber attack or otherwise. But just to focus on the countermeasures question for a minute, I guess I would like to ask the question of whether, let's assume there's a cyber attack of some kind, that it is reasonably foreseeable to cause a harm that is otherwise that is prescribed by international law, and so a state has a right to respond with countermeasures, as limited by international law. And I'd like to get your view on whether other states that are not directly affected by the cyber attack may also respond in countermeasures, whether there's what's known as a right to take collective countermeasures in response to an unlawful cyber act.
So yeah, this is a particular aspect where Estonian President Kersti Kaljulaid made a kind of even unexpectedly revolutionary statement in last May during the opening speech of Saigon. And According to her, according to Estonia's official position, yes, states may respond in a collective manner to a cyber attack, and the argumentation for this, backing up this very bold claim, was mostly that it does not necessarily bring about escalation or lead to escalation, but on the very contrary, it might lead to use of more of milder measures to respond. Because when we imagine a state that is under a severe cyber attack and thus lacks the technical means, but at the same time is working in close alliance with other states, but the other states are not allowed to step in, then this victim state might in fact choose harsher avenues of response. So, and secondly, also the nature of the cyber domain and shared responsibility, and just the very fact that one vulnerability occurring on the territory of one sovereign nation state directly influences the overall structure. So these arguments were chastised and praised on an equal extent. Still, I mean, there are not many states coming up with equally bold statements. It is often criticized that it opens up new opportunities for opportunistic, unnecessary aggression, but against, let's say, unnecessary aggression under the protectionist agenda. But against these claims, I would say that collective or not, countermeasures still have to be proportionate and feasible.
And could I'd like to pin you down, if I may, on, let's just be sort of technical lawyers for a minute and ask the question, if you're going to take the position that collective countermeasures are in some circumstances lawful, they have to be proportionate, they might be intended to have a non-escalatory effect, how do you grapple with the draft articles on state responsibility in this context? Do you say that collective countermeasures are generally lawful, and the suggestion in the draft articles on state responsibility that they're only permissible when taken by a state that is specifically injured is wrong, is dated? Or do you say that cyber conduct is in some way different, so that the ordinary principles on countermeasures and the injured state criterion that the ILC offered up don't apply in this context? So sort of how do you weave that doctrinal, whatever the metaphor is?
There's this, first of all, unfortunately, I missed part of your questions because of some kind of a delay, but it was only a very minor part, so I think I got the majority of it. So another question, which is more complicated, is exactly what kind of a cyber attack can be responded to in a collective manner? Is there such a thing as a violation of an erga omnes obligation in cyberspace, or what the exact nature of a cyber attack that can be replied to in such a manner? This is something that because of the lack of state practice, this is something that we cannot illustrate, or we cannot offer any real life examples, illustrative examples that would help to put this issue into context, unfortunately. So it's not a matter of whether there are some kind of cyber attacks that might constitute a universal threat. Probably there are, but whether they have occurred already, and what is the criteria that we could use to decide whether this particular cyber attack qualifying as, let's say, use of force, but not an armed attack, then what kind of cyber attack could actually bring about collective response?
Uh-huh. Okay, great. Well, I feel like I could sit here and talk to you all morning, my time. But I see that we're running out of time. So what I want to do is I want to ask another question and then ask each of you to weigh in. And if you have thoughts about the countermeasures question, you're welcome to also respond on that question. And the more general question that I want to ask is there's a lot of uncertainty in the law that governs cyber, both at the broad, like general prescription level and as applied in concrete cases. So even if we can agree, for example, that some cyber conduct might cross the armed attack threshold, it's hard to figure out exactly where that is. And so there's quite a bit of uncertainty. And the question, I guess, I have for the governmental lawyers who are actually advising clients on a regular basis in this space is how do you lawyer in the face of that uncertainty, and how do you use international law to sort of guide your clients in light of, Doug, something that you mentioned earlier, both the offensive and the defensive nature of this domain and what states are doing here. So the question is, how do you lawyer in this context? And for the non-governmental lawyers, I guess the question is, what prospects do you see for further clarification of the law? Do you think that is something that's realistically in view, or do you think in the near to medium term we're likely to continue seeing this uncertainty? So, Doug, I'll start with you, and then we can just go Doug, Sue, Chuck, Jianrong, Anne, and wrap it up.
Thanks, Monica. I'll try to be brief. I mean, how do we approach this? I think what we try to do, as I said at the start, is look at cyber power in the round, understand the linkages and interaction between the domestic and international legal frameworks, which we're applying both at the same time to the same situations, as will many other countries. And cyber isn't unusual in that sense. You know, there's many areas of state conduct and international affairs in which you have to approach it in that vein. And what I would say is that certainly over the last few years, there's a lot more common understanding and common cause about the general principles and application of those principles than there was before. So I think it is possible to overstate the uncertainty in this area, even recognizing that we want to see further discussion and alignment of how the law applies to specific activity. And what we're trying to achieve by that is both an ability to attract, as we're able to do in a whole host of areas, international alliances around calling out bad behavior. We've seen a range of countries do that in recent years, and also understand the rules applying to the projection of cyber power, because we can't have a situation, I think, for those countries that subscribe to an international rules-based system are unable to project that kind of cyber power in the defending forward way that Chuck mentioned, and that such activity is confined to those countries which have no regard for the rule of law, at least in their covert actions. So what we're trying to do as international lawyers is like any other area, especially emerging areas over decades, understand the law as it applies, come to common understandings as to what activity is permitted and what is not. And then I think there will, over the course of future years, be room for progressive development and rulemaking in this space when the time is right, and when the countries can come together to do that in a meaningful and sensible way. Thanks.
Beautifully said, Doug. I agree with many of those sentiments, so thank you. So in Quicktime, I think I just want to add, what do? We start with fundamental first principles, and we go from there, and we have to understand the object and purpose of what the law is trying to do. And then I think one thing we've really tried hard to do is, in this space where the law is less certain, we have tried to publicly express our view of where the legal interpretations lie, because we believe we have responsibility as states and state practice to do so, recognising that state practice in this area is hard to describe at times, and so we're left more with describing our opinio juris, I think. But I think if states aren't willing to do that, to fill that gap and describe their own, bright lines, if you like, others will fill that gap for us and may take the law in a direction that we think is less useful, and that's why we have been really attempting to make public some of those legal views, and through our case studies as well. And I know NATO has done this as well. I think the case studies are really good example of trying to show the application of the basic principles of international law to hypothetical situations, and to show that legal reasoning, how it can assist in defining international wrongs and promoting peaceful dispute resolution processes. And I'll leave it there so someone else can say something.
Well, thank you for those comments. Actually, what Sue said is plays exactly into what I wanted to say, which is that I think we need to take into these questions a sense of both humility and pragmatism, and also adhere to, as Sue said, first principles. We need to keep in mind that that balance is required. That the same rule of international law that we conclude authorizes the U.S. military to conduct a cyber operation, can also legitimately be applied against the United States. We need to avoid opportunistic shifting of legal views and instead provide consistent advice, principled advice. But I think that what I wanted to comment that some of the speeches that we've referred to, I'm very, very happy that in the last administration, the Obama administration, a number of speeches, people got together and said, what good are we if we cannot get out there and announce what it is and explain why things are being done the way they are. And thus you have, in this context, the Coe speech in 2012, the Egan speech in 2016, which talked about elections tampering even before it was seen as a big deal in this country. Then we followed up with some other speeches that I'm happy to say much the same has been done in this administration. And I was intrigued by many of the things that were said, including what Anne said about what Estonia's statement on collective countermeasures. I'm really intrigued by that. And I think this process should continue. After Paul Nye's speech, there certainly have been some critiques. And I could easily blame the pandemic as to why we haven't gotten some posts on there to respond to them, because it's been just an unprecedentedly difficult time for everybody. But these are things that we're thinking about, and discussions like this one, I think, are going to serve us really well, and particularly the opportunity to hear from states. And the last thing I'd say is continued participation in the norm creation, even in the sense of non-binding norms. The group of governmental experts that has been going on. I was so happy in looking forward to this event to see how much work has been done since approximately 2010. And so I just think we need to continue that. We need to be, as I said, humble, understanding that no one has the corner on the market of righteousness on these matters, and we just need to be open to each other and keep exploring, keep listening to one another. Thank you.
Wonderful. Xizhang? Oh, you're muted. You might want to unmute yourself.
Yes. Can you hear me? Yeah. So I think the application of international law in cyberspace is a useful first step towards rule of law in cyberspace, but that international legal framework as applied in cyberspace is too general to provide the necessary legal certainty, and that uncertainty needs to be addressed. I see two possible approaches. One is enhanced discussion and dialogue among nations. I would like to mention the two ongoing processes within the UN, the OEWG and the UNGGE. For example, China in last September, for the first time, submitted a position paper relating to, at least partly relating to the application of international law in cyberspace, which is publicly available. So that shows the discussions among states had generated encouraging progress. And the other is the possibility to supplement, to fill in the gaps in international law with soft law initiatives. And this is what is already being done in reality. So for example, in the 2015 UNGG report, we can see the report confirmed in paragraph 28b that states must comply with their obligations under international law to respect and protect human rights and fundamental freedoms. At the same time, the report also made the view in paragraph 13, that's the section on norms of responsible state behavior, that state in ensuring the secure use of ICTs should respect the relevant Human Rights Council resolutions as well as the General Assembly resolutions to guarantee full respect for right to privacy, right to freedom of expression, and other human rights in the digital age. So it's just like how the 1948 Universal Declaration of Human Rights, which was non-binding at that time, elaborated on and clarified the human rights provisions in the UN Charter. So I think this trend, the mutual reinforcing of soft law, the non-binding norms, and binding international law will continue in the coming years.
Wonderful, thank you. And I have like Asil whispering in my ear that we're running over. So Anne, I'm gonna ask you to wrap up for us with some final comments if you have any, and then I will say thank you. And
as for the last question, just very quickly, as among one of the panelists who has no experience as state legal advisor, then I would like to hear, pay homage to everybody involved in fact forming the state of Vinio Juris and cyber matters, because recently, I would say during the last 2 years, we have been reading and receiving interesting, relevant, on point and strong writings expressing state opinion units. We have Australia, UK, Netherlands, and Estonia and France expressing explicitly their positions on international law as applied to cyber operations. And in addition to this, we have a legal vocabulary and let's say legal sounding statements or legally meaningful statements in national cybersecurity or cyber defense strategies, increasingly so, gradually more and more. And for me personally, this is even more of an interesting and relevant read, and I deem it to be more significant to the emergence of international cyber law as some of the many soft law or norms instruments, to be honest. So this is where I would really like to show my appreciation to everybody, in fact, involved in creating this kind of expressions of state legal opinion.
Well, I think that expression of gratitude is a great place to end. So I want to thank all of you for taking the time to meet with us today. And thanks to ASIL for having us. And thanks to our audiences who are still with us, maybe the 2 or 3 of you. And so I look forward to learning more about these topics from all of you as life progresses. So I'll just clap on behalf of everyone in the room. And goodbye.
Thank you, Monica. Bye.